key. That has facilitated a model called no full, no fee. So you can engage with the lawyer. If they think you've got a decent case and you've a good chance of winning, they're prepared to engage with you. That has the added advantage for the state that basically you have your lawyers screening out nonsensical cases in the first instance. So that's a win. So instead, what we're actually being presented with here is a situation where there is some scheme, we don't have any of the details about it, basically, which says, in the first instance, there will be no order as to costs. But how do you then cover your own costs? How do those people there actually deal with the massive legal bills that they would need to pay their own lawyers? This is the fundamental issue. What we know from the bill is that they intend that the Minister for Public Expenditure and Reform will have sort of a final say on it. We very little else, but that is leaving something entirely to the discretion of the political regime to be able to titrate a scheme which isn't clearly specified in primary legislation and won't necessarily be specified in primary legislation, which is subject to political control to be tweaked. Now, I, on Friday and Saturday of this last weekend, attended the Civil Legal Aid Review, the Chief Justice's conference associated with that. And I was moved to tears hearing the stories about people and the challenges that they have with legal aid on the most emotive cases around family law, child law, you know, just horrendous things. And the regime that we run in this country is appalling. And we had members of the judiciary reflecting on it. We had the legal profession, we had civil society NGOs reflecting upon it. What hope for the environment if we can't look after the most vulnerable in our society, our children and our family? And that's the type of scheme that we're effectively proposing that we would put this in. We have a system which works, and what is needed is additional measures to provide for that broader concept of legal assistance, you know, and that is fundamental. We have not been consulted on this as part of the Planning Advisory Forum. The wider public hasn't been consulted on it. We haven't a clue what we're getting. We're getting a pig in a poke here, and that is no way to legislate on something as profound, and that will drive huge issues. What do? Do you apply for legal aid first? Sorry, this is one really important point.
If you could just be concise,
do you apply for legal aid first? You know, and then do you have to appeal that? What does that do to the time frame? Or do you have to go in with chilling uncertainty, which will be immediately problematic in terms of EU law and the Aarhus Convention, in terms of that you only get your clarity after the fact? What happens about injunctive relief? The decision is live until it stands, and if you basically are pursuing a claim for aid so that you can take a case, in the meantime, what happens with the development and the status of that permission?
Okay,
we don't provide for injunctive relief at not prohibitively expensive cost also.